Hey, welcome everybody. In today's case, we are going to break down a case that deals with fiduciary duty and specifically a breach of the duty of reasonable care. So let's dive into it. The case opinion in this was actually issued in 1994. This comes from a California Court of Appeals, but the story actually starts back in 1917. The buyers in this case were the plaintiffs, and their parents were actually peasants in 1917 Russia. And at that time in Russia, the parents had no land, no property rights. And so growing up, the plaintiffs in this case were born in Korea as the parents escaped Russia during that conflict in the revolution in 1917. And so growing up, the parents instilled in the buyers in this lawsuit, their children, they instilled the value of property ownership and they told them stories. So fast forward up into 1979, where the children had grown up and they find themselves in California, it was very important to them that they had property that they could leave to their children because of the stories that their parents told them from the Russian Revolution. So the buyers, they talked to the real estate agent and they told him, this is what we want. We want a large enough piece of land that we can subdivide it and leave half to our son and half to our daughter. So each child would have a half acre each. And the agent told them that in this particular county, this area that you're looking in, county ordinance requires that a parcel of property be at least 1 acre in size in order to subdivide it. So that's what we're looking at. We got to find you a parcel that's at least 1 acre. And the agent told him that's going to take some time. I mean, those aren't, a dime a dozen, right? They're rare. They come on the market every so often. And the buyer said, that's okay. We are in no rush. Just let us know when something comes up and let's look in this specific area here. So that was the arrangement. So the agent is keeping an eye on the MLS and watching new listings pop up. And lo and behold, a little while later, listing pops up in the buyer's preferred area that is advertised as 1 acre plus. And there's nothing in the MLS that would indicate that the listing was a misrepresentation in any way. Everything looked good. So the agent gets on the phone with the buyers and says, hey, think we found a property. It's, at least 1 acre. Let's go take a look. So they do. So they get to the property and they take a look around and they really like it. And they spend some time outside to really examine the size of the lot. Remember, it was critically important that the lot was 1 acre, at least, in order to subdivide it. So they spend some time and they notice on the land that there is an old fence. And the agent's looking at it, looks at the southern fence and looks at the northern fence and says, this is about 1 acre. You're going to have no problem subdividing this for your purposes of leaving the kids a half acre each. So the buyers are thrilled, put in an offer, and offer's accepted. We go through to closing, and a little while later, the buyer then goes to try to subdivide the lot, and they find out that they cannot, because a true measurement and a survey of the land showed that the property, that fence line on the southern border, was off by almost 1/10 of an acre, about 5,000 square feet. And so the true lot size of the property came out to be about 0.998 acres. And the county rejected the buyer's bid to subdivide the property. Buyers stuck with this land that they cannot use for their sole and intended purpose. So what do the buyers do? The buyers file a lawsuit against their own real estate agent, alleging that the agent committed constructive fraud. And by virtue of committing constructive fraud against them, the client, that was a breach of the duty of reasonable care. So they go to trial, and the trial court agrees with the buyers and basically says, hey, you agent, you should not have relied on the information in the MLS and then just relayed that information to the buyer and said, this is a 1 acre property. You're good to subdivide it. You were not acting reasonably and carefully, and by virtue of making the statement that the property was 1 acre, that was constructive fraud. Now that decision by the trial court can raise your eyebrow, right? I mean, after all, real estate agents, they see properties on the MLS all the time, and that information on the MLS, that's a representation of the property. And so they're going to use that information to ascertain whether that property fits the criteria of the buyer or not. So pretty standard practice in using that information to make some determinations of whether we should show that property. So of course, the buyer's agent, not happy with the results, appeals the decision, and it goes up to the Court of Appeals in California. So let's dive into the appellate court's analysis and see kind of how they thought this through and what the law is, and see what decision the appellate court landed on, and then we're going to find the learning points through this case. The court starts out with what the buyer's agent knew. It says, he knew that the size of the property and its ability to be subdivided was critical to plaintiff's decision to purchase it, yet misrepresented to plaintiffs that the property was more than 1 acre in size and that it could therefore be subdivided. He confirmed that the size of the boundary of the property was marked by the fence and failed to disclose that he had done nothing to independently confirm the accuracy of this information. So right away, we see that the court, as it begins its analysis of the facts in the case, is already leaning towards the idea that an agent should not be making claims about property size without verifying the information. And now the court goes through the law. In addition to the traditional liability for intentional or actual fraud, a fiduciary is liable to his principal for constructive fraud, even though his conduct is not actually fraudulent. Constructive fraud is a unique species of fraud applicable only to a fiduciary or confidential relationship. All right, so this is really interesting. You might remember back in real estate school the different theories of fraud. You've got intentional fraud and constructive fraud. And remember, intentional fraud is really where we have that malicious intent, so to speak, of misrepresenting or withholding information and defrauding the other party. The court says, aside from that, when you are an agent, when you are a fiduciary, now it opens up another theory of fraud that's applicable only to agents in a fiduciary relationship, and that is constructive fraud, where your intention does not matter. The court says, as a general principle, constructive fraud comprises any act, omission, or concealment involving a breach of legal or equitable duty, trust, or confidence which results in damage to another, even though the conduct is not otherwise fraudulent. And notice there that italicized, that the court is really emphasizing that the conduct is not otherwise fraudulent. Most acts by an agent in breach of his fiduciary duty constitutes constructive fraud. So I'm going to jump in there real quick and note that the court is kind of acknowledging that agents typically don't go around defrauding their clients, right? In the vast majority of situations, agents are good, they are honoring their client, they are upholding their fiduciary duties, and they're not performing any actions that would constitute intentional fraud. And so the court's noting here that, look, most cases where fraud is at play with a client and an agent in that relationship, it is a constructive fraud issue because the agent's conduct was not intentional, but still liable. The failure of the fiduciary to disclose a material fact to his principal, which might affect the fiduciary's motives or the principal's decision, which is known or should be known to the fiduciary, may constitute constructive fraud. Also, a careless misstatement may constitute constructive fraud even though there is no fraudulent intent. All right, so we see from this, the court spends a lot of time just kind of acknowledging that intentional fraud may not be applicable in a lot of cases in that agent-client relationship. However, constructive fraud can still arise just by virtue of a misstatement by the agent that ends up causing harm, injury, or damage to the client. The court says a broker who is merely an innocent conduit of the seller's fraud may be innocent of actual fraud. But in this situation, the broker may be liable for negligence on a constructive fraud theory if he or she passes on the misstatements as true without personally investigating them. So now the court is really setting up the law as it applies to this particular situation. The agent received information from the MLS and passed it on to the buyer and said, we got a 1 acre property, you can subdivide it. And the court is saying that just being a conduit of information, right? The information is received and then it's given over. That alone will not give rise to the level of actual fraud, intentional fraud. But it could give rise to constructive fraud if we're not investigating or verifying the accuracy and the correctness of that information that we are acting as a conduit for. The broker has a fiduciary duty to investigate the material facts of the transaction, and he cannot accept information received from others as being true and transmit it to the principal without either verifying the information or disclosing to the principal that the information has not been verified. Because of the fiduciary obligations of the broker, the principal has a right to rely on the statements of the broker, and if the information is transmitted by the broker without verification and without qualification, the broker is liable to the principal for negligent misrepresentation. And this is where the rubber hits the road. The client, presumably not well versed in real estate, has a right to rely on their agent or broker and the statements that that agent or broker provides. Right? They have a right to say, hey, that is information that I can use and it will shape my decisions, and I should have a right to say, hey, I can rely on the truthfulness of that information. Therefore, the burden is on the broker or the agent to say, hey, the information that I'm giving you, the information from the MLS, is accurate. Or, the court says, the broker has to give some type of qualification to that information. In other words, say, hey, this is what the listing is advertising. I don't know if it's true or not. We have to qualify that information. That's what the court is really kind of saying here and laying out the groundwork for what the result in this case is going to be. So the court is basically setting up the fundamental question. Did the agent in this case verify the information or inform the client that they had not verified the information? Either one of those two things is going to relieve the broker's liability in this case. So let's see what happened. As a fiduciary, the broker had a duty to his clients to refrain from advising them that the parcel was more than an acre, that it could therefore be subdivided, and that the fence represented the southern border of the property where he did not know that to be the case and where he knew these facts were material to plaintiff's decision to purchase the property. While he was not required to investigate the seller's representation or the truth of the description contained in the multiple listing service sheet before showing the property to plaintiffs, the broker was at least required to tell the plaintiffs that he had not verified the information he was passing on to them, that he was simply relying upon the description provided by the sellers. Now, the broker argues that his conduct was merely negligent and not fraudulent. However, the disclosure duty is a general duty imposed on the agent, and whether a breach of that duty constitutes negligence or fraud depends on the particular circumstances of each case. Consequently, there is no clear line establishing when a fiduciary's breach of the duty of care will be merely negligent and when it will be characterized as constructive fraud. However, a breach of the fiduciary duty usually constitutes constructive fraud. The trial court determined that the broker breached his fiduciary duty to plaintiffs by making affirmative statements as to the size, boundaries, and subdividability of the property, knowing these facts to be material to plaintiffs, and by failing to disclose that he had not confirmed their accuracy. The trial court concluded that such breach constituted constructive fraud. Substantial evidence supports that determination. All right, so that's what happened. The broker took the information from the MLS. They went out, they looked at the property, the broker said, hey, the fence line here and that southern fence looks to be like this is a 1 acre property. Go ahead and subdivide it, you're going to have no problems. They tried, they got rejected because the actual fence line was off and therefore the property was much smaller in size. And the court said in this appeal that you can't just rely on information without telling your client that you have gone above and beyond and verified that information, or you haven't, and it's up to them. So really interesting case, right? In my opinion, I think many courts, no matter which state you're in, would have no difficulty really following the analysis and the conclusion that the California court here came to, because it's not that large of a burden to put on a real estate agent to say, hey, you're getting information from the seller and the listing agent, right? You're getting that information from the multiple listing service sheet. And now what are you going to do with it? You're just going to give it to your buyer and say, hey, this property is, 3,000 square feet or 1 acre or whatever it is that is so important to you, and that's it? And the buyer's supposed to trust and rely on you conveying that information? Remember, the buyer is at a disadvantage. They're relying on you as a professional. So, I don't think it's a big burden to say, hey, buyer, I haven't verified this information. This is what the advertisement on the MLS says. Let's go take a look at it. But ultimately, through your due diligence, you're going to have to verify the size of the property or whatever it is that's important to them that's in that sheet. Or if the agent wants to go above and beyond, they can look into some things. They can get a copy of an appraisal, request one. They can go searching through county records and verify some claims that are on the MLS sheet. So the court is not saying that you have to go do that. There's no duty to verify. In fact, the court said that. The court said very explicitly in the opinion, there is no duty to investigate the claims of the seller. You just can't take the information and say that's the truth. You've either got to investigate it. That's not a high burden. And I would dare say because it's not a high burden and it's just, really good service. And therefore, I believe that many courts would have no issue following this no matter which state that you're in. So it's a good lesson. I used this precedent in my jurisdiction when a broker came to me with a very similar set of facts. In that particular case, it was flipped. The broker that came to me was a listing broker, and she put the property in the MLS and just inadvertently, accidentally typed in the square footage wrong. And so along comes the buyer, and they submit an offer. They believe that the square footage is what's advertised on the MLS, and they put in an offer for market value. Parties accept, and they move forward in the transaction. Buyer has the appraiser come out. The appraiser takes measurements of the property and finds out that the property is actually 200 square feet less than what's advertised on the MLS sheet. And so the buyer is, of course, livid and upset because they are essentially paying for a property that they believe is larger than what it really is. So in essence, they're overpaying. And by my calculations, when I looked at the case, I think it was about a $40,000 swing on what they would be paying price per square foot for a larger property versus what the property actually was. So the buyer, they lawyer up. They start making their demands. And the situation comes where they're potentially going to file suit against the seller and this listing broker for the misrepresentation in the MLS. Now in that situation, we had 3 attorneys involved. We had the buyer and their attorney, who was really initiating that dispute. We had the seller and their attorney, and then we had the broker and myself. And so the 3 attorneys are the ones doing all the communication and working on this dispute and, trying to initiate settlements and trying to move things forward and, talk of lawsuits and actions. And in that case, my research, I came across this precedent. Made the argument to the buyer's attorney that if, in fact, that buyer is going to file a lawsuit against my client, we are going to rope in the buyer's agent into that lawsuit as well. And we're going to split the liability with them because the buyer's agent had a duty of reasonable care to the client, which was to verify the information or explain to the client that the information had not been verified. And that's not that hard of a job to do for the buyer's agent, especially in our jurisdiction where the MLS has a button you can press that will literally bring up the government records on the property, and the agent could have easily have seen the discrepancy before ever submitting an offer and then, working that out beforehand. So that was our claim, was that we're going to loop in the buyer's agent too. And that pretty much took the legs out of any lawsuits because of the connection that the buyer's agent had with the buyer at the time. It was a very personal connection. So it is a good case that has a lot of legal weight to it in this type of situation because the buyer's attorney, took that, looked at the precedent in California and looked at our situation, and they basically conceded. And we had a very favorable settlement to my client on that. So the bottom line is, guys, as a buyer's agent, you do have a duty of reasonable care. You can't just shuffle papers and information. You got to do something a little bit more. You've got to either verify the information given, or you got to explain to your client that you haven't, and that they shouldn't rely on it, and that they should do their own due diligence. And so for a lot of agents, they think, well, that goes without saying. It's due diligence, and it's in the contract to do due diligence. And you're right in a larger picture, but still, I would not just take information and give it to the client. I mean, that's what this case is all about. You got to do something a little bit more with that information. So I hope you liked the case. I hope you liked the lesson that's embedded in it. Again, I think it's a good lesson. I think it's a very basic principle that really doesn't put a high burden on the agent. I think it's just good service, if anything. But I also know that there's a lot of agents that don't do this. They just take that information, they say, hey, this property is everything you want. Let's go take a look. And that buyer is relying on those statements. So just remember to qualify the statements. Now I'm going to drop the case link into the description below. You're welcome to go read it for yourself and really take some time studying this and what that agent did and what the court was saying should have been done. I think it's a really good case to learn from. Remember guys, nothing in this video constitutes legal advice. We're just taking this case. It's a great case, breaking it down and seeing the lesson learned from it. Now, if you do have a situation like this, always consult with a competent attorney in your own jurisdiction because there's going to be facts and nuances in the law that apply in your neck of the woods, right? And is going to affect any given legal analysis. But I hope you like the case. Hit subscribe, hit the like button to signal to other agents out there that this is a good case with a good lesson, very interesting set of facts that, frankly, we can see in most transactions, most situations with agents. So subscribe and follow, get notifications on the next release, and we will see you when we break down the next real estate case.